Good evening, everyone. Welcome and thank you for joining our event, The Art of Advocacy, Understanding What Makes a Good Advocate and How to Become One. This is an event collaboration with aspiring barristers and is hosted by Durham University Non-Law and Law Society and the Public Speaking Society. I'm Neha Vasist and I'm the president of NILS, and I'm a third-year English literature student at Durham University, and I will be co-hosting today's event. Firstly, we would like to thank aspiring barristers for agreeing to host this event with us and arranging a fantastic group of guest speakers to share with us their skills and experience in advocacy. To briefly introduce aspiring barristers to all of you, aspiring barristers aims to support aspiring student barristers from underrepresented groups within the profession on their journey towards the bar. They hold a myriad of events such as mentoring schemes, networking events, and essay competitions. So feel free to reach out to them and join their events in the near future. To share some information about NILS, we work towards facilitating a smooth transition for non-law students at university into a career or further education in law, allowing them to demonstrate their commitment to law. I will now allow my co-host for tonight, Thomas, to introduce himself and our esteemed guest speakers. Over to you, Thomas.
Thank you, Neha. Hi, I'm Thomas from the Public Speaking Society. I'm a second-year law student from Durham University, and our society mainly holds public speaking-related events such as Model United Nations debates and public speaking workshops, so don't miss out on our events if you're interested. So with us here today is Mr. Baldip Singh Aulak, human rights barrister at 33 Bedford Row, who practices family and immigration law and is an advocacy trainer at Inner Temple. Mr. Felix Gibson, future pupil barrister at 5 Paper Chambers, who was also part of the 2021 International Law Moot winning team representing Grace Inn, and Mr. Samuel March, barrister at 9 King's Bench Walk, who specializes in crime and regulatory law. Please note that this event will be recorded, so feel free to turn off your camera if you wish to. As housekeeping rules, please make sure to mute yourself until the Q&A segment of tonight's event. We expect you all to follow this to ensure the event runs smoothly. However, in the case that there are any disruptions, we may be required to remove the attendee from the Zoom meeting. Each speaker will take turns answering questions we've prepared regarding oral and written advocacy. So without further ado, we'll first start with Mr. Aulak, if you're ready. So the first question is, what structure would you suggest that students should aim to follow when making oral arguments or submissions in order to make them as persuasive as possible?
All right, let's get straight into it. Well, that's the purpose of a barrister, isn't it? To be as persuasive as possible when putting their client's case forward to the bench or the tribunal. What we say as advocacy trainers, that when you make arguments, oral and written, and your submissions, that there needs to be a clear aim. You need to set out what the judge has been asked to do and the source of the power to do it. One needs to be very court-focused, tribunal-focused in terms of the overriding objective. We need to help the court as best as possible in terms of the law, but also as quickly and succinctly as possible in order to determine matters. So we need to set out to the judge straight away what the issues are, what the judge is being asked to determine at today's hearing, and the power and source for them to be able to do it. As advocacy trainers, we would look at whether or not the arguments are structured. Are they logical, with a clarity of expression? And the way I have always suggested to my students has been that you use the statute and the tests laid out in case law to guide your submissions. That is the law that needs to be applied to a case. You refer the judge to the sources of power, the legal tests that have to be met, and you apply step by step the various sections of that statute that apply to your case, all the tests laid out in case law to your set of facts, to your case. And I think that makes for a good structure, because it really does help the judge in terms of a checklist of ticking off what they're being asked to do. You can also employ a logical structure, a beginning, a middle, an end. That always helps. Just how we used to write stories and poems at school. Similarly, that sort of structure can assist in terms of persuading a tribunal, helping the tribunal make a decision. In terms of being persuasive, I know this is quite a basic, but it's surprising how often it arises in terms of feedback with new practitioners and pupils, that one needs to be audible, one needs to hear the submissions and make sure that they're heard. You've got to be speaking at an appropriate pace. You'll have noticed in my tone of voice that I have gaps in relevant places. And I would hope that if someone was taking a note of what I'm saying, I was talking at a pace that they could take a note, which is exactly what a judge would be doing. I won't speak like this throughout, but I wanted to use that as an illustration of how to pace oneself. And often people ask, how do you pace yourself? And it's not quite clear, but something similar to that, so that one can be understood, so that one can be heard, and someone can take notes of the salient points that you're making. It's all good and well making all the points, but if one is missed or they are misheard, which is even more dangerous, you're not an effective advocate. You've got to have a clarity of expression and use the appropriate language, and you've got to adopt it to the tribunal you're before. And that's really important, to be able to be persuasive in your oral arguments. For example, if you're in front of magistrates, particularly lay magistrates, you may want to break down the law. You may want to simplify things in terms of the language that you're using, because these are non-legal professionals, although advised by their legal clerk, legal advisor. So addressing the court in appropriate language is also really important in terms of being persuasive. It's no good me going in before the magistrates having very complex legal arguments that are going straight over their heads. It's my job to interpret the law, to make sure that the law can be understood by anyone hearing me, whether that be the lay bench or whether that be a judge from the Supreme Court. You've also got to have interaction with the tribunal, and I'd add dealing with the opponent's arguments, because the interaction with the tribunal is trying to understand what it is that you're trying to say, trying to understand what it is that they're being asked to do. And if you're the first on, it's always helpful to deal with your opponent's arguments, to anticipate them. Not to overly anticipate them, that you give them all the points that they should be making and may not make, but the key ones you can anticipate, so you can deal with those. I think there's an element of confidence that comes with practice to make oneself persuasive. And the more you practice the art of advocacy, the better you get. So taking up opportunities like debating societies, public speaking societies, mooting, and so on is really important, because I think everyone starts off as pretty embarrassed of their videos, of their advocacy. And in fact, it doesn't get any better. The more senior you get, you pick out more faults in your advocacy through time. So getting involved in terms of practicing advocacy will make you more persuasive. I think that's what I would say in terms of making yourself persuasive in oral arguments and submissions.
Thank you, Mr. Aulak. So the next question is for Mr. Gibson. So the question is, what would your advice be regarding concluding arguments to ensure a lasting impact?
Hi, everyone. So as regards concluding arguments, I think it's important to bear in mind the way that we generally structure submissions. We don't save our best till last. That would be silly, because once we reach the end of submissions, our tribunal will be more tired than they were at the start. And so in terms of the conclusion of any moot, I think it certainly shouldn't be anything that's surprising. It's really just a chance, not so much to make substantive arguments in themselves, as it is to sum up your position again. And it's been my experience, because I'm talking about mooting. I am not yet a lawyer. I've never, stood up in a court. So I imagine it may well be different in courts. But in mooting, concluding arguments are the one area where the sort of very dignified, cold-blooded approach that we in England take to mooting and to court advocacy is allowed to be warmed by a little bit of emotion. And there can be a little bit of a sort of a flourish to it. And in fact, at the risk of sounding flippant, I think that this confidence in concluding is almost as important as the substance of what is being said. Because like I said before, you really shouldn't be saying anything new in any concluding argument. I've got a great anecdote that's really embarrassing to me about when I took part in, I think, as was mentioned, I took part in the Jessup International Moot Court competition. I don't know if anyone here has done that or knows the rules of that, but it's a fantastic competition. I really do advise anyone who enjoys advocacy to get involved. It was fantastic fun. But the way that that's structured is that both sides make submissions, and then the applicant makes a rebuttal of the respondent's arguments for maybe 2 minutes, and then the respondent makes a sur-rebuttal so in effect they rebut the rebuttal for another 2 minutes or so. And I did this moot. I was the respondent, and it was my job to do the sur-rebuttal, which I always try to make as sort of fiery as possible to leave this lasting effect. But the thing is that it's a team event, the Jessup, so I had to have my teammate on hand in case there were any arguments that needed to be made in the sur-rebuttal that related to issues that I wasn't covering. So what we did is he would WhatsApp me. He'd send me via WhatsApp the arguments he'd like me to make on his points. And I would read out his WhatsApp message and then make the arguments on the issues that I knew. It was a sort of shared thing. And then one moot came along when I was scrolling through the WhatsApp messages and I completely lost the thread of where I was. And I read out WhatsApp messages from an earlier moot. And so I was here reading out arguments that did not relate to the moot at hand. But I read them out with perfect confidence and clarity, and then I made some arguments of my own. And would you believe it? The judges didn't notice. The judges didn't notice because for them, what really matters and what really will stick out is that this ties together the threads and that this is a confident ending. And that clearly that objective had been achieved, and bizarrely enough, we won the moot. I thought I'd probably have sunk it with my awful sur-rebuttal, but we won it. And I say this, not to be stupid, not to show off, certainly not to say that you should do something like this, but just to emphasise how important it is that there be a sense of finality in what you say. One thing that I think is good in terms of this theatricality that I mentioned is if you can find some sort of identifying theme or a caricature almost, if you want, of the two positions. So if you're able to, to look at the whole landscape of arguments made by your opponent and say, opponent has made these ridiculous, piddling legal arguments, putting form over content, and is attempting to trip us up with fine words, whereas here we are, with common sense on our side, asking for basic decency to be upheld. Things like these are a great vehicle to tie together the submissions that have been made. Claimant has made a ridiculous argument about abusive process, not using that sort of language, but it allows a quick recap, and then you can draw these things together by alluding to these very vague abstract principles, these sort of colors that you can apply to your respective positions, which make yours sound like they are appealing to the better principles. And related to this idea, I think it's a very good idea as well to recap some of these sort of intuitive reasons why a judge might want to find for you. And like I say before, these should not be new reasons. These should not have come out of a hat, but there's something to emphasize in concluding submissions. Of course, what you want is for the judge to want to find for you. And so you need to have a think about some of the things that judges are averse to doing. If you can argue that your opponent would, if they had their way, force the judge to stick their neck out by doing something unorthodox, would force the judge to expand the criteria for something, or establish a new test, or push some boundary further, or fail to develop the law in the proper way. If you can suggest that, if you can emphasize ways that the judge can want to find in your favor, then that's a very good thing. So I think really then my tips would be to sort of summarize those up. Number one, really don't worry about the substantive content, because finishing is much more important, and having that character and having that confidence is what's important, and what the judges will be looking for. They're going to notice bad style in conclusion. They really will. Secondly, I'd say find that theme, find that thread to tie together, and broad brush color the submissions of you versus your opponent, and do so in a way that is a nice refresher that casts your counterpart submissions in a light that is favorable to you. Really emphasize any knee-jerk reasons why a judge would want to find for you. And the final thing I'm going to say is that you should know when to stop. The art is knowing when to stop, isn't it? And that's a problem that I think we often see in mooting, is that advocates feel scared at the thought of just stopping and just leaving the floor open. So they talk and talk and talk, because as long as I keep talking, then there's no chance that I'll miss something out. And if something comes to me, then I can say it. And actually, this sounds bad, this sounds frustrating. And any sort of brilliant crashing finality is watered down. You're diluting the power of your submissions. So that would be my final point when you're making your concluding arguments. When you've made this brilliant appeal to judicial common sense, and you've colored the relative submissions well, and you've done so with, with loads and loads of panache, just know when enough is enough, and know when to stop.
Thank you, Felix. Those were really helpful points and pointers for all of our participants. My next question is to Samuel. What advice or tips do you have for advocates presenting before an audience who do not seem particularly engaged while delivering an argument? For example, a member of jury?
So 5 short points on that. The first is to be concise. The second is to read the room, whether that's a jury, a lay bench, a Crown Court judge. Know when the point that you're making is tanking, and if you don't absolutely need to make it, just move on. Some judges will be kind enough to indicate that they don't think that that's your best point. That's the critical moment when making submissions. If you don't need that point, that's a good time to move on. If you absolutely need it, you're doing something wrong, you need to double down and sort it out fast. My third point, use natural language. You may have prepared a skeleton, you may have scripted this out in advance, but you need to put those things to the side. Unless you are speaking to someone the way that you speak to an actual human being, your voice is going to come across monotonous, robotic almost, and the actual sense of the words that you're using will disappear. That brings me on to my fourth point, which is that conversation is more engaging than lecturing. Difficult with a jury, less so with a judge or a lay bench. If you can get any conversation going, people will listen. That can be as simple as starting your submissions before a judge by asking whether they have your skeleton argument, and by asking whether there's any points that they would like you to start with, and put the ball in their court as to how they would like to hear your submissions. The more two people talk to one another, the more they both leave having understood what was said. My fifth and final point, which is difficult on these kind of webinars, is to use eye contact. It feeds into all of my other points, because you're not going to be able to read the room if you're not making eye contact with the people that you're speaking to. You're going to get lost in your script or your notes if you keep looking at them and don't look up at the person that you're speaking to. You're not going to have a constructive conversation if you don't look at the person who you're speaking to. With a jury, you need to actively remind yourself that there are 12 people there, and your eyes may naturally be drawn to one or two of them just because of where they're sitting, or because they might be taller or dressed more loudly, or appear even to be more engaged in what you're saying. But it's really important that you take time during an opening or a closing speech to spend a few seconds at a time looking at each juror, building that slight connection with them and making them feel like you're actually there speaking to them.
Thanks, Samuel. My next question is to Baldip. What engages and impresses you most when training other advocates in your role as an advocacy trainer at Inner Temple?
Okay, this was an interesting one. The event is called The Art of Advocacy, so I hope we all know what a case theory is. But what impresses me the most is when someone has a clear case theory when presenting their case. For those that don't know what a case theory is, if you just break down the word, it's your theory about the case, about the facts, about your client's position, okay? So often we have advocates who are not clear what their case theory is. What are they saying? What is their client saying? What's their client saying about the event in whole? What are their clients saying in respect to various bits of evidence that go against them? So having a clear case theory, a purpose, a map in your own head is very important. So I think that's what impresses me the most when, as advocates, we read all of the papers and we step back. We are not stuck to the brief or our client statement as gospel. We step back and we look at all the evidence as a whole and see how we are going to perform, how we are going to present this case to the tribunal. So it's really important to have a clear case theory. Without it, you're lost and you'll lose those that are listening to you as well. So you've got to identify the issues, whether the legal and factual, in your own mind, have that clarity. You've got to look at all the evidence that's in your bundle and outside and within your knowledge that you can bring to the case and craft a narrative that will persuade the court to find the other advocate's argument less favourable. You've got to then apply that narrative to the evidence. It's all good and well having a story in your head of the events that led up to the assault or the murder, but if you can't apply the relevant evidence to support your narrative, it's not persuasive. Then it's just you making something up, and it will not come across as plausible at all. You've got to decide what evidence to adduce from your own witnesses and the other witnesses to support your case. So all going back to impressive advocates. They know what questions to ask and what questions to avoid. They know what to ask of the other side's witnesses. They know what needs to be challenged and what doesn't need to be challenged, and what to undermine and what to protect, so that their narrative is more persuasive. So when coming up with a case theory, I think it's really important you're not a slave to your brief. A brief is a document that sets out your instructions. Because if we just verbatim spoke out our brief, there wouldn't be any need for us as advocates to be persuasive. So it's really important that you have a case theory in your head. I think that applies to anything. You've got to have your argument. You've got to have your version of events to make them plausible, to make them approved or accepted by those that are listening. So keep your case theory short and simple, logical and realistic. Make sure your case theory complies with the law and the legal tests that should be applied. Your case theory has to be consistent with the facts. And most importantly, your case theory must tell a story. That's what makes a good advocate. That's what I'm impressed with. It must be ethical and you shouldn't mislead the court. And it should be emotionally appealing to the finder of fact. So you can press on the emotion, some common knowledge that those that are listening to your case theory can apply. And I think ultimately, the best sort of advocate is the one that leaves you thinking, well, that's common sense, isn't it? To go any other way wouldn't be common sense. That to me is persuasive. And I think the question also asked, enjoyable, what I find enjoyable in terms of advocates is a style, is their tone of voice. What's important is that you bring your voice as an advocate to the table. You don't fit a mold of how you should sound or how you should behave when presenting a case. So don't fit the mold, bring your personality to it. That's what makes it enjoyable to listen to, rather than someone trying to fit a mold. You, as a person, as a human, bringing that element to a case. So that's what makes a good advocate.
Thank you, Baldip. So my next question is for Samuel. Could you please share how you went about identifying any areas of improvement and methods of practicing oral advocacy?
Yes, so I'm going to focus this on the kinds of advocacy that you're likely to come across in two main scenarios. The first being end of court scholarship interviews, and the second being pupillage interviews. If you are looking to pursue a career at the bar, the next few years are going to be full of interviews and written applications. And there were 4 things that I did in preparing that I think helped set me in good stead for both oral and written applications and interviews. The first is mock interviews. The second is what I'll call star responses. The third is something called signposting. And the fourth is keeping a little book of hot topics. So turning first to mock interviews, if your university has a careers service, that should be your first point of call for these. I'm sure that your university will. Many of you will go on to do the GDL or the BPTC, or possibly the new solicitors qualifying exams. Wherever you go to do that, that will likely have a specialist legal careers service as well. Careers services, especially where after my undergraduate degree, I went to the University of Law, where they had a brilliant career service for aspiring barristers. I could ask to have a mock interview with them. I could ask for lists of previous interview questions. They kept a running list for different chambers, different Inns of Court, different levels and types of interview. And also a bank of mock advocacy exercises that I could practice. Once you've done that, if you think you need more, contact someone who's already got the thing that it is that you want. That might be someone who you can see on Twitter got a scholarship from the Inns of Court that you're applying to. It might be someone who was recently a pupil in a chambers that you're applying to. There is absolutely no harm in asking people for help, especially people who make it clear that they're always willing to help. I had a very helpful mock interview with a junior tenant at the chambers where I now have tenancy. And that was a really safe space to practice different styles of interview responses and get a taste for the sorts of things that are likely to come up in interview. If you've done that, or if you're too shy to do that, or if you don't want to do that, just try with your friends. Get a group of people who are applying for similar things, tell each other what you're applying for, and prepare a short interview for one another. A first round pupillage interview might be 3 questions, 1 hot topic, 1 CV question, 1 legal question. A second round interview might be similar, but also with a mock advocacy exercise, a bail application, or a plea and mitigation if you're doing crime, or a summary judgment type legal argument if you're doing civil. I move on now to my second point, which what I referred to earlier as star responses. This is something that you should try in those mock interviews. STAR is written with 2 R's, and it stands for situation, task, action, result, and reflection. Situation should take up only about 5 or 10% of your overall answer. It might be as little as a line. When I was doing this position, when I was at this job, task will set out the task that you were faced with. I was asked to prepare X argument, or I was representing so-and-so in this kind of hearing. Action will be where you start to show what it is that you did that was special, or that shows that you have whatever skill it is that they're looking for. I presented my arguments in X way. I did this to try and help get a very difficult client back on board. That tends to be a little bit longer, whilst the previous 2 might have just been a line each. Your action you're going to want to talk about for about 20 to 30% of your overall answer. Then result. that actually may be a surprisingly quick bit, again, just a line or two, but that's where you show why it is that you succeeded. And that should be evidenced ideally with either a metric, if you were in a job which you had key performance indicators, a clear win, if it was a particular kind of hearing or competition, a grade, if it's in reference to an exam, and so on and so forth. And finally, reflection. This is likely to be your longest bit. It may go into well over a third, and it's the bit that often people just miss out. This is where you link everything that you've just said back to whatever the interview question was, and use it to show why you're self-aware and why you're going to be good at whatever it is you're interviewing for. That was star responses. My next point, and you may have noticed that I'm doing it very, very obviously in this webinar, it is something called signposting. And the reason that I'm doing it obviously is so you can get a sense of how it's done. Signposting is where you begin an answer by laying out your stall, and then you stick to the structure that you said you were going to stick to. Very often you number your points, and you can tell someone before you even begin to reply how many points you're going to make. That can stop you from repeating yourself, from repeating yourself, from getting lost, or from what Felix was talking about earlier, just going on and on and on at the end. My fourth and final point is to keep a little book of hot topics. Interviews, written applications, the whole lot, you will always get a series of hot topics that come up on any given year over and over again. In the year that I was applying, it was knife crime and Shamina Begum. I must have answered questions about those in countless interviews that year. Any given year, the topics will be different. A couple of years before me, it would have been Brexit in every single interview. You need to know what those topics are going to be, and you need to keep a little book about them. What I'd recommend is putting the title at the top. If it's kept online, a link to something, to anything interesting that you read about them. And then most importantly, 3 points for and 3 points against whatever's an issue. Because if you're used to listing things in 3 and you know that you've got 3 points in everything, you can open your answer by saying, I'm going to mention 3 things. And you're already signposting and showing that you're answering questions in the sort of way that they're looking for you to answer them. Now, in terms of identifying what those hot topics are, if you don't have Twitter, get on it. It was one of the most useful tools for me in keeping up with industry. It's completely different and separate from my Facebook, where my friends are. I use it almost entirely to follow people in law and politics. If you're not a fan of Twitter, subscribe to something like a mailing list. Witness is a good example for anyone interested in criminal law. It's a short mailing list that has about 5 news stories sent out every Saturday. I made it a challenge for myself to already know what those 5 news stories were going to be before I received that. And if there were no surprises in Witness on a given Saturday, I knew I was on top of the big issues in criminal law that week. I think that those are my tips on how to prepare for the sorts of advocacy you're likely to encounter in pupillage interviews and scholarship interviews.
Thank you, Sammy. The next question is for Felix. So for aspiring student barristers, the first step into advocacy activities like mooting, mock trials, debating, etc. can be quite daunting. Felix, you were part of the winning team for the 2021 International Law Moot. Could you please share any tips that helped improve your advocacy skills when engaging with these sorts of activities for the first time?
Yeah, absolutely. I think well, I'm going to take a leaf out of Samuel's book, and I'm going to do a bit of signposting. There are two things that you really want to practice, aren't there? There's getting your content right, and there's getting your style right. And the content is probably the trickier one of the two, especially if you're new to mooting. Tip number one is a boring one. It's you must prepare. You must prepare. You must learn the problem inside out. You must know the fact pattern inside out. You must be intimately familiar with the case law and with the statutes and whatever else. You must be able to answer questions on them. You must be able to quote them backwards. Again, analogy from Jessup. This competition, it's a moot that it has a fact section of about 10 pages. And certainly in the weeks leading right up to the oral rounds, it was fairly standard for teams to read that every single day to make sure that they had it absolutely by heart. Because one thing that judges will enjoy doing is testing just how well advocates know the material by asking questions. And if you know it, you'll be able to answer those questions well. But more importantly, if you know this stuff well, then you won't feel so nervous. If you know this stuff well, intuitively, then you can talk about it like it's second nature, and you will be better. You'll be a better advocate. The other tip, I think, in terms of content, and this is about first mooters, isn't it? So I think this particularly applies to people who haven't sort of got the feel of it yet. Is you should get a sense for how, for whether it's predominantly a legal issue, a legal debate you're having, or a factual debate. So what I mean by that is, you know, if you're being asked some deep questions about consideration in pay less and pay more cases or whatever, and it's a sort of appellate moot about the law, that's one thing. If it's some sort of, I don't know, some sort of magistrate's hearing, it's very fact-based, and that's another. And you should understand that those two things require you to state the law very, very differently. So if it's a very legalistic thing, then yeah, stating the law in detail is great. But something I've seen quite a bit, especially from new people, is when they're doing something like the sort of hearing you might have in a magistrate's court or a family court, something that's very heavy on the facts and on the people, the human beings and the particular circumstances. They set out the statute and they set out the relevant statutory test and the powers whereby the court has, you know, jurisdiction to hear this test, and the factors that the court must take into consideration, and where all these are found, and in which statutes these are found. And I think, my God, you know, imagine that you're a judge sitting in this sort of tribunal. You know, you'll hear these sorts of cases day in, day out. If it's something that's fact specific, then a judge will know the law. So please don't. I think perhaps new mooters recite the applicable law at great length because it's a crutch, but get a feel for whether it seems like the sort of thing where the judge would know the law. And if you think, yeah, a judge knows the law and actually this is all about arguing about the facts, then it looks much more impressive and much more businesslike to go straight into it, to say, you know, this is a Section 18 application, you know, to say whatever it is, briefly setting out what you're arguing for, without feeling the need to set out law that the judge already knows. And this, following on from what I said about knowing your material, another tip I've got for new mooters is that whatever you do, you should not have a script. That's a really bad idea. This sort of, I guess this bleeds towards style as well. Do not write out a script, because you're an advocate, not a newsreader. You know, you could, if it were just a question of reading out a script, you don't need to be there. You could pay an actor to stand there and read out something you've written. And actually judges will pick up on this. And if judges see someone reading off a script, I know plenty of people who, when judging moots, they'll deliberately ask a bunch of questions to try and test the mooter's actual knowledge if they see someone reading off a script. And even if judges don't do that, it looks less impressive. People can always tell when you're reading off a script, and it doesn't look as good. It also impacts your style, I think, quite badly. It means that you speak in a bit of a monotone, and that will lose the tribunal's attention. No matter how good your script is, you'll be utterly sunk if the tribunal asks you to focus on a different area or reconsider something, or give submissions or something else. but it also really affects your style. And that's the other thing. That's the other thing that's really important. And here I think Baldip has already identified really the crowning principle, which is whatever you do, be yourself. Just talk. Don't put on a voice is what I would say is the main tip. A lot of new mooters will put on a voice, some sort of weird, plummy RP. All of a sudden, they'll stand up very straight and they'll enunciate in this Victorian manner that sounds completely unnatural. I saw one person mooted in this way, you know, in this very, very composed, very stilted way. And then as soon as she was asked a judicial question, her shoulders relaxed and she spoke in her normal voice, and the contrast was pretty startling, and not in a very good way. It looks artificial and it feels uncomfortable. So please do have the confidence. You know, some of the best mooters in the world are the University of Sydney team that seem to repeatedly win the Jessup Championship. And they moot in very heavy Australian accents. They don't feel the need to put on any funny voices, and they do very well. I know mooters who speak in all sorts of accents in all sorts of ways. And as long as you speak clearly, as long as you can moderate your tone, as long as you can speak at a good pace, as long as you can be heard, then it doesn't matter what your accent is like. A couple of other pointers for style that I'd have feeding into this. One of these is about speed. You always need to speak slower than you think, because we have a tendency to speak quickly when speaking before an audience. If it helps, maybe speak so slowly you think it's slightly ridiculous. I guarantee that if you deliberately make an effort to speak slowly, you won't end up hurrying. But if you speak at what you hope is a normal pace, you can end up hurrying. I think the final point in relation to style is don't feel the need to clothe everything you say in long words and polysyllables and spun out sentences. Be brief and be to the point. Brevity is the soul of wit. You really need to remember that. You know, let your content speak for itself. No judge will be fooled by fancy long words. They'll be won over by the strength of your arguments and the common sense of your manner. So really be yourself, speak up, speak slowly, and just speak in plain English. Make sure that you know the facts, know your stuff. Don't use a script whatever you do, and you will have a fantastic time. You will genuinely enjoy it, and it will show, and the judge will find for you, and it will be the start of a glorious mooting career.
Thank you, Felix. Our next segment will be about written advocacy, and my next question is to Baldip. Is there an expected number of examples that advocates should aim to include when making written arguments or submissions to ensure their effectiveness?
I'd start off by answering that question by firstly saying that most courts and tribunals have their own practice directions in terms of number of pages in a document that's submitted in terms of skeleton arguments. So make sure you're complying with that. In terms of whether there is an expected number of examples, firstly, I'd highlight the word that's being used consistently throughout this evening, and that is brevity and conciseness in terms of being persuasive to be an effective advocate. So I'd hope my response to this question is testament to that by saying you should put enough in there to get the job done. And that's what we're paid for. So long as you are clear and it's a logical structure, you've identified the issues, you put your salient points first, your strongest points first, it's an appropriate length, it's digestible. You've got to also look at the timescales. For example, in a case we're doing in the Supreme Court, they wanted skeleton arguments in 4 weeks ahead of our hearing, whereas in magistrates and district judges lists, often orders, say 24 hours before a hearing, or 11 o'clock the day before the hearing. And the reality is that if a judge is in court all of that day, they're not going to read it until either that evening or the following day, first thing in the morning. I am sure they will appreciate a 2-page document over a 30-page document. And I can assure you, you'll be right in guessing which one they've actually read and which one they haven't had the opportunity to fully consider, which will then mean you'll have to go over everything in your 30-page document compared to a 2-page document that they've certainly read. So long as it gets the job done, I think that's my suggestion in terms of the number of examples in any written arguments or submissions.
Thank you, Baldip. My next question is to Samuel. You were awarded the BPTC Drafting Award for excellent drafting by the University of Law. What do you consider makes for poorly drafted written advocacy?
Thank you. I just firstly wanted to apologise for I disappeared there briefly. Someone was at the door and ringing repeatedly, and I'm the only person in the house. In terms of what makes poorly drafted advocacy, I've drafted a quick 6 points of how to piss off the judge. The first, failing to answer the specific question or address the limbs of the specific test. There is no excuse for not doing this in writing because you've actually had the time to think about what it is you're putting before the judge. If it's a civil defense statement, that means it needs to address every single line of the particulars of claim. Anything that you fail to address, you will be deemed to have admitted. They're very slightly less brutal in a criminal defense statement, but if you fail to mention something in it that you later becomes a key part of your defense in court, that can be held against your client. If it's a skeleton argument, make sure you've checked the exact wording of the legal test, mirror that wording, answer that test, and address every single limb of it. Point number 2 of 6, you can piss off a judge by mixing your structure. Decide what structure you're going to take for written submissions and stick to it. And especially when you're first starting out, be really brutal with yourself about the rules that you make, even if it feels a bit unnatural. If you're writing a skeleton argument, have a section on facts, have a section on the law, and have a section on your submissions. Don't let the facts bleed into the law. Don't let the law bleed into the facts. The submissions is where you tie it all together. So your facts section can literally be a narrative about what's happened with a series of cross-references to where in the evidence they can find those facts. The law will be citing directly from statutes or cases, just pretty much listing, ideally in a digestible order, the relevant law that applies and the test that applies. And your submissions use the facts, the relevant facts, to apply the law in this case. Point 3 of 6, you can piss off a judge by mistaking your skeleton with your oral submissions. Someone's just written a question. Can I please repeat the section in a skeleton argument? I mean, I don't want to be prescriptive in all and every single case, but in a vast majority of skeletons that I write, section on facts, section on law, and then your submissions. So I just moved on to, yes, mistaking your skeleton with your oral submissions. You need to have things to say in court. I don't know whether you've ever been to a PowerPoint presentation where somebody puts the PowerPoint up and then turns around to look at their PowerPoint and reads it to you line by line, but it's the most tedious thing you can sit through because you can read and you will very, very quickly get shouted down by a judge, I can read, if you just start reading your skeleton argument to them. So you need to keep in your head the purpose of the skeleton argument. That is largely, you get down the key points, especially the stuff that's really boring to talk about or not particularly in dispute, or where you just need to make sure that you've got the references to where in the evidence you can find the facts, references to what case a particular principle or what statute a particular principle comes from, so that you can move much more quickly orally to your submissions and develop on those. So your written style shouldn't be the same, possibly more casual, it's quite casual in court, but certainly conversational style. Your skeleton's concise and to the point, and you can elaborate on that orally. And you can weave in and out of your skeleton argument, and you can say, and the law on this is addressed at paragraphs 4 to 6 of the skeleton argument. You don't then need to read that out, just give the judge a moment to read it in his head. Point 4, I mentioned cross-references a second ago. A really easy way to annoy people or to lose time in court is to fail to cross-reference. If you are writing a piece, you have time to do this properly. There is no excuse for not knowing exactly where the things that you are saying can be backed up. Because if there is just a hanging assertion that X happened or that Y is the law, then a judge is you're going to end up in court and say, you take me to paragraph 5 of your skeleton argument. Why do you say that that's the legal test? And there's no excuse for not having made it clear where you can go to check that. Similarly, if you're citing the various quantities of cannabis seized in various different exhibits, it's really helpful to have the exhibit numbers next to them. This was touched on in point 5, touched on a moment ago, missing deadlines. Almost all written advocacy is going to have a deadline. And these deadlines can be incredibly important for the case and for your client. You could be risking wasted cost orders if you miss them. Oftentimes it should be your solicitor's job to make sure deadlines are met, but not always, and very often, even if something is a solicitor's job, if counsel's been instructed from the beginning, they'll be expected to have considerable input, if not draft the entire thing. Make sure you know when your deadlines are and do not miss them. And the final point, having something that's too long. If you really want to go into court with a judge who you've already lost, send them a 20-page skeleton argument when it could have been 2 or 3 sides.
Thank you, Samuel. So the 9th and final question is for Felix. From your experience with mooting, how do you approach structuring your written submissions in order to make them as persuasive as possible?
Thank you. Well, I don't think I'm going to have a huge amount to say on this question because I think Samuel has just done a much better job of answering that question than I ever could. So please, pay attention to what he said because he's a proper barrister, unlike me. So far as structure goes, I think he's obviously hit the nail on the head. So I suppose then I can just offer a few thoughts about style, perhaps, insofar as I'll just be emphasizing further a theme that's already appeared a few times, which is that brevity is so important. And it, of course, is not always the case. What I mean by that is that in the Jessup competition that I did, the written submissions are very, very long. So who knows, maybe you'll do a weird moot that asks for very long, elaborate written submissions because it's done in some unorthodox court or something. But generally speaking, of course, yeah, skeleton argument should be very, very short. My girlfriend works as a paralegal in family litigation. Recently, a QC turned up to a trial with a skeleton that was a grand total of 1 page long. I think it had about half a dozen lines on it. It was incredibly short and to the point, and it didn't need to be longer because it is a skeleton. It's something on which the muscle hangs. It's not the muscle itself. So that's the thing to remember. And it is important, therefore, that your style can be as quick and brisk and minimal as possible. And to this end, folks, I'd like to read to you, if you aren't already familiar with them, George Orwell's 6 rules for writing well. Rule number 1, never use a metaphor, simile, or other figure of speech which you are used to seeing in print. Number 2, this is really vital, never use a long word where a short one will do. Number 3, if it is possible to cut a word out, always cut it out. Number 4, never use the passive where you can use the active. So, you know, never say, I was hit by him when you could say he hit me, for example. Number 5, never use a foreign phrase or a scientific word or a jargon word if you could think of an everyday English equivalent. Number 6, break any of these rules sooner than say anything outright barbarous. And he's absolutely right, I think. I hope you'd all agree that George Orwell is a good guy to go to for writing advice. It really is a question of being as succinct as possible and letting your spoken advocacy do the talking for you.
Thank you, Felix. So today's event has come to an end. We'd like to once again thank Mr. Aulak, Mr. Gibson, and Mr. March for taking your precious time away from your commitments and share your experience and ideas on advocacy with us. I'm sure I can speak for all the attendees, including myself, that we have learned so much from your invaluable sharing today. Once again, I would like to take this opportunity to thank Visa and Alice and the rest of the team at Aspiring Barristers for making this event possible by agreeing to collaborate with NILS and DUPSS. Lastly, I would like to thank all the participants. Thank you for joining us today and making this event a successful one. Good evening, and we hope to see you all again in the near future.
Thank you, everyone.
Thank you.